that's good. So, okay, so you probably had a little message recorded in progress. So that basically is just letting you know from now on we've hit the record button. So anyone who doesn't want to be on camera, if you can just click your camera off. Thank you. And then really this is for just to push our Benevolent Fund now. This is something that is really close to our hearts, is, you know, safety professionals. We know a lot of people have been struggling over the pandemic. People have lost their jobs, and safety practitioners are not out of that zone. There's many people who have been consultants and they found themselves out of work and in a situation where they've needed to reach out. And one of the routes of help, if you like, is we've got an IOSH Benevolent Fund. And without reading everything out word for word, there's something really simple you can do for the Benevolent Fund. So any of you who are on the screen who basically order things from Amazon, next time you order, if you just do Amazon-Smile, and it just takes you to, it's like a portal which is still Amazon, but it means for every pound or penny you spend, there's a donation made by Amazon to your charity. So you click on the drop down list and IOSH come up there, and if you click on that, it means it doesn't cost you any more money, but Amazon actually puts some money in, you know, for donations to the charity, and this goes back into the fund for helping members with whatever they need, really. So anyone who can support that, or if you just want to donate yourselves, then just please have a little look on the Benevolent Fund page. So thank you for that, everyone. And without further ado, Lauren, if I can just introduce you, if you want to share your screen and introduce yourself, I'll be quiet and let you take over.
Thanks, Michelle.
Thank you.
Okay, bear with me. Okay, hopefully you can all see my screen now, Michelle. Is that coming through? Great. All right, brilliant. Thank you. Okay, so welcome everybody. As Michelle said, thanks so much for joining the legal update today. My name's Lauren Rigg. I'm a Principal Associate at Waitman's Solicitors. My colleague Ppe Thomas, some of you might be familiar with, he often comes along to these events to do this presentation. He's on holiday this year, so he's handed the baton over to me, so I'm very pleased to be here. Again, hopefully you know Dowie, and if not, you might know Waitman's. We're a national law firm, and within our team in regulatory, we deal with a number of regulatory cases, and that includes health and safety, of course, in terms of both contentious and advisory matters, inquests and public inquiries, transport and motor crime, environmental, food safety and hygiene, trading standards. So we really cover the entire breadth of regulatory and criminal defence matters within our team. Hopefully that will be reflected in some of the topics that we will discuss throughout our presentation today. I'm hoping to not keep you much more than half an hour or so, although if any of you know me or know lawyers, we like to talk, so I'll say that. But if it goes on a little longer, Michelle or Paul, happy for you to send me a message to move me along slightly. Okay, all right, without further ado, let me proceed with these slides. Okay, so in terms of what we'll cover today, I'm going to go through a number of topics with you. COVID-19, an update on HSE decision making. I'd like to think that hopefully by the time we get to next year, COVID won't appear on these updates, or it'll be a small footnote to say it's all forgotten about. But for now, I think it's still important and something that we'll cover, albeit I'll keep it as brief as I can. I know we're all sick of hearing about COVID. We'll then touch upon a health and safety sentencing update, some recent cases of interest, some hot topics which are arising within safety at the moment, and then what's on the horizon, so what might be coming up in the next 12 months or so. Okay, HSE spot checks and their decision making in relation to COVID-19. So, as many of you will know, prior to the pandemic, HSE and local authorities, they would come out and conduct inspections on businesses, and they could be unannounced inspections or announced inspections. And there were often routine, HSE just coming out every now and again, or if there was a report of a concern or an injury or an accident, HSE or local authority would of course turn up to conduct an investigation. But when the pandemic hit, those routine inspections stopped, and HSE and local authorities in the main were only conducting inspections outside of COVID-related inspections if there was a report of a fatality or there was some other serious concern that had been reported to them. And instead, they focused their attention on these COVID spot check inspections. And using HSE's words, they've been trying to ensure that businesses are COVID secure when they've been coming out to do these inspections. As some of you might well have had the HSE turning up at your businesses to make sure that your business is COVID secure. And there's been quite a bit of concern about the use of that phrase COVID secure, because given the nature of COVID and what it is, and the ability on businesses, or the requirement on businesses to only do what's reasonably practicable, can we ever actually ensure that a workplace is COVID secure? Is that even possible? And I know there's been some talk within the industry as to the unfairness of that phrase, but despite that, HSE and the government have continued to use it. And during those inspections, HSE have been finding, and still, despite obviously things coming towards the end, well, hopefully the end of the pandemic now, they're still seeing similar issues arising during these inspections. Common themes have been things such as failure to provide arrangements for monitoring, supervision, maintaining social distancing, adequate cleaning, welfare regimes, and so on. And those are the issues which a HSE have found. Now, despite there being quite a lot of issues that have been found on these inspections, up until just last week, we hadn't seen any prosecutions arising from it. So this, I'd done a very quick update to my slides in the last couple of days, because just the 17th, so the end of last week, there was the first prosecution, which arises out of a COVID spot check. And that is the unfortunate case for him of Mr. Umar Akram Khattab. And this was a Manchester case, and the inspection was July 2020. The HSE inspector had performed one of the proactive COVID-19 spot check inspections at a construction site.
HSE.
Sorry, I think that. And during the inspection, there were a number of health and safety issues identified, which included working at height, COVID-19, site security and electricity. And the principal contractor in that case, Mr. Khattab, was served with a prohibition notice and 2 improvement notices. The inspector came back a couple of months later in August 20 and found there'd been little or no improvements made following the issue of the notices. And in fact, a further prohibition notice was then served in relation to unsupported excavation works, and they served a PN in relation to those, and found that essentially the contractor hadn't complied with the previous improvement notice that had been served. So they prosecuted the principal contractor under section 2.1 of Health and Safety at Work Act, and I'm sure you're all familiar with that, but just in case there's anybody who isn't, that is the offence we most commonly see in health and safety prosecutions. And what section 2 does is impose a duty on employers to take all reasonably practicable steps to protect the health and safety and welfare of employees. And it's such an easy hurdle for the HSE and the prosecutors to get over, because all they have to do for a section 2 is establish some form of material risk to employees. And once they've done that, the burden then shifts to businesses as the defendant to prove themselves that they have taken all reasonably practicable steps. So it's not the typical innocent until proven guilty that we often hear thrown around in England as to convictions. It doesn't work that way for this particular offence. So we often see that in cases, as we did here in this particular case. And also there was a CDM offence that was prosecuted as well. It was a guilty plea, and the defendant was sentenced to a 12-month community order and £3,000 worth of costs. And as I say, it's the first one, not a strict COVID prosecution, because clearly there were many other issues that were found. But there's some comments from the HSE at the end of that case was that they've carried out more than 316,000 of those spot checks. And they've so far demonstrated the majority of employers are trying to do the right thing. And this is the first prosecution to arise from that spot check programme. and HSE have basically said that we've pushed and pushed this, and prosecution is a last resort. And in a case like this, they obviously felt that they didn't have any other option but to use their powers to take enforcement action. So interesting that it's taken all this time before there's been a prosecution. And the next slide just provides a little bit more information as to how the HSE have been dealing with things so far. Now, these figures were produced following a report from the HSE in April, and given what the HSE said in the case I've just mentioned, 316,000 inspections, there've obviously been a lot of inspections taking place since then because the numbers increased dramatically here. But you'll see from this slide, and I won't read it out word for word, but quite unusually for the HSE, in my view, they've been adopting quite a lenient approach to these cases when they've conducted spot checks and found issues with COVID measures. Now, that is maybe perhaps unsurprising, given that we've got a global pandemic, and even where there have been outbreaks in work environments, there's so much uncertainty around source and the research and the guidance. This is something completely new that they've been dealing with, and that, I'm sure, has impacted upon the HSE's decision making and why they've chosen to approach the majority of cases in this way, as you'll see on the slide, in terms of the verbal advice that's been given, a very limited amount of enforcement notices, and as we've just heard, only one prosecution so far. Whether there'll be any more remains to be seen. I think, in my view, as with the case we've just talked about, they will be reserved for those most serious of cases. So where we've got somebody having been served with improvement notices or prohibition notices, and there not being any learning, and the HSE going back to site, again, I'm sure you all know that that's red rag to a bull, so to speak, to the HSE. When they turn up and there's no action being taken, you're pretty much guaranteeing that you're going to be prosecuted after that. And clearly they felt in this case that was the only option available, given the steps that they'd already taken. And I can't see there being many, if any, prosecutions going forward, except in situations like that where it is so serious. Okay, I'll touch on at the end in terms of the current position in relation to COVID when we're talking about hot topics, because the spot checks are still ongoing despite obviously restrictions being lifted and focus shifting away from COVID in a number of respects. But those inspections are still ongoing, and it is still something that employers need to be aware of. So we'll come back to that a little bit further on. Okay, so health and safety sentencing update. The introduction of the sentencing guidelines in 2016 is old news now, I'm sure, for many of you. And it was the introduction of them in 2016 was such a dramatic shift for lawyers and practitioners and businesses, because what those guidelines did was really up the ante in terms of the fines that courts can impose for health and safety and food safety offences. It really was a huge change for all of us. And those particular guidelines, the health and safety sentencing guidelines, they're complex, and they're probably a session in themselves. And many of you may have been to them over the last few years, whilst everybody's been getting to grips with how the sentencing guidelines are applied. So what I won't do is take you through a detailed application of those guidelines, because A, most of you will know them, and B, we'll be here for 3 hours if we do that. So, but what I will do is, just before we get on to some recent cases, is just give you a short summary, just to remind any of you. I suppose for some of you, you might have had the fortunate experience of not being prosecuted, your companies or individuals not being prosecuted for health and safety offences. So in that case, you might be less familiar with them, which is of course positive. But the reason why there was such a shift following the introduction of the guidelines is in relation to the levels of fines which can be imposed now. Prior to the introduction of the guidelines in February 16, there was a cap on the level of fines, most of which was £20,000 in the Magistrates' Court. And what these guidelines do is remove that cap. The fines are now unlimited. And how the fines are now applied is based on turnover. Again, you might recall pre the guidelines, we were concerned with profitability when looking at levels of fines, but now the starting point when looking at level of fine is turnover. And the process that we go through in terms of applying the guidelines is a staged one. So when there's going to be a prosecution, there's a guilty plea or there's a sentence, we look at the guidelines, and the first stage is taking an account of culpability. So how serious was the breach? And the guidelines give us an assessment from very high, medium and low in terms of culpability. And then we look at how serious was the harm risked. And this is one that's often quite difficult for organisations, because we're not actually, if there's been an accident and there's a prosecution, when we're looking at assessing where the case fits on the guidelines, we're not concerned with what harm actually occurred. So if, for example, an employee suffers an amputated finger, but actually the harm that was risked as a result of the breach was a fatal accident, then the court is concerned with that harm that was risked when assessing seriousness rather than the harm that actually occurred. And then lastly, how likely it was that such harm would occur. So if we're looking at the fatal accident scenario, how likely was it that that harm would occur? And again, there's some quite arbitrary descriptions in the guidelines of high, medium and low, which aren't particularly helpful. And that likelihood of harm is something which is often a sticking point now in sentencing, because quite often the HSE and the defendant will have very different views on how likelihood that harm was to occur. And where possible now, what we're often doing is instructing experts to try and help with that, particularly in the technical cases. For example, in a halves case, an expert can be really useful in this scenario to establish, well, how likely it was based on the systems and procedures that you might have had in place to control hand-arm vibration and exposure. Based on that, and based on the condition of the employee and the OH records, how likely was it that that harm was to occur? Because that's quite difficult for a judge or a lawyer to tell an organisation without the input from an expert. So more and more that experts are being used purely to deal with that likelihood of harm aspect on the guidelines. And the reason why that's the case is because depending on your analysis on those three stages of culpability, harm and likelihood of harm will really then impact upon where the case sits on the guidelines and really bring that level of fine down. And then, as I say, once we reach a point then in terms of where it sits on the guidelines, it's then taken into account of turnover. And the larger the turnover, the larger the starting point for the fine. And the court will then move up or down. There's a starting point for a fine suggested by the guidelines, and the court can move up or down within the ranges, depending on aggravated and mitigating features. And as I say, hopefully that makes sense, and it is a session on itself, and I'm sure most of you will be familiar with, but hopefully that gives you a flavour as to the guidelines and the process. And because of the unlimited fines now, companies are a lot more concerned often when there's a breach, and given the way now these cases are reported on social media and how the publicity for these cases, because often of the levels of fines, is so much larger than it used to be. There's so much more focus from the press and social media. There's so much more risk of reputational damage which arises as a result of breaches. And many of you will find that within your organisations, if you apply for tenders, quite often there's a question asked on there, about your enforcement record. Have you had any prosecutions? So again, just really important to be aware of that. And again, for individuals, they have the potential of 2 years imprisonment if an individual is prosecuted, criminal records, director's disqualification orders. So it really does impact upon somebody's future, both in terms of organisations and their ability to carry on in business should it receive a hefty fine, and also individuals in terms of their personal life. Now, as I say, the guidelines came in, and the reason why the guidelines came in, and they were looking to and they upped the ante so much in terms of fines, was to really send a message to industries that you need to take health and safety seriously, and that's why they upped the ante. And secondly, to try and give organisations some certainty as to what level of fine they might expect. And you'll see there on the slide from the introduction of the fines in 2016, you'll see they start to peak following introduction in 2016, and then they start to come down slightly after that as the courts become more familiar with the guidelines and how they are to be applied. Now, no doubt for this year's statistics, which we haven't had yet, that line will continue to come down even further. But this year is obviously going to be a bit of an anomaly because of the pandemic and the impacts that has had on industry in terms of the amount of people at work, the amount of accidents, and the HSE prosecutions and investigations. So I expect that over next year we'll come much further down, but then it will start to peak again for 21-22 as things get back to normal. That's just another table to give you a bit more of a clearer picture on fines. The graph isn't overly clear, so that just gives you an indication there of the peak in 2017-18 for the fines, and then as they start to come down slightly in 19-20, and it'll be interesting to see where we get to once we get through 2021 and that anomaly back to the norm for the figures for this current year. The next slide along gives you some indication as to sector. These figures are 19-20, and you'll see there where the higher fines were in terms of the different sectors. So construction is very high, 8.2 million. Manufacturing, 16, water supply, you'll see quite a few in the millions there. Agriculture is at the top there in terms of the total fines, and is of the lower end in terms of the total. But there was a recent publication from the HSE in terms of agriculture in the industry, which looked at fatalities between March 20 and April 20 and March 21. And in that period alone, there were 13 people killed by moving vehicles, 11 killed after an injury by an animal. And just after that, there were another 4 deaths on farms. So I'm just doing the maths, 28 fatalities in that year. So whilst agriculture in terms of total fines is relatively low, that I'm sure relates to the turnover of the businesses within that industry. And in fact, sadly, agriculture is still up there with one of the most risky industries. Prosecutions against individuals, again, just a short snippet, we're slightly behind from the HSE here in terms of figures, but you'll see there a drop in terms of immediate imprisonment and suspended imprisonment sentences, and an increase in community sentences. And again, no doubt that's due to the measures and the pressure on the prison service, that the court is opting to go with community orders rather than those custodial sentences. Okay, so moving on then to give you some illustration of some recent fines which have been in the press recently. Tesco stores, one of obviously our household names, have recently been in hot water before the court. And this was a prosecution brought by Birmingham City Council under the Food Safety and Hygiene Regs. It was in April this year, and Tesco pleaded guilty to 22 offences across 3 stores for 67 items of food that were sold past the use-by date. And I mentioned just earlier about not these guidelines not just being relevant to levels of fines, but also reputation. And all the I don't know if anybody saw it, but splashed across the press in relation to this particular court case was that the judge in the Magistrates' Court described Tesco's admissions as probably the most reluctant guilty plea in legal history. Which, you know, I mean, don't get me wrong, I'm sure many people are still off to Tesco for their local shopping, but from a reputation perspective, it certainly doesn't bode very well for them. So combined with those comments made by the Magistrates' Court judge, they were fined £7.56 million in order to pay costs of £95,000. And that's the highest food safety fine that we've seen. And commentators were quite surprised that Tesco didn't appeal that, given the level of fine. Its turnover in that time, just out of interest, was approximately 50 billion. And just referring that back to the guidelines that we've been discussing, I mentioned the starting points for the levels of fines and ranges, and where an organisation has a turnover which is over 50 million, which is a large organisation, the only guidance then given to the court in terms of where to pitch that fine is that it can basically go where's necessary to achieve a proportionate sentence. So based on that, the judge obviously considered for those number of offences and a 50 billion turnover, once they had credit for a guilty plea and so on, however reluctant it was, that 7.56 was a proportionate sentence based on that turnover. Interestingly, about 7 months before this particular case, Tesco were fined 160,000 for similar offences. And that was one of the reasons why people were so surprised that they didn't appeal. And I think what that shows is that whilst the guidelines are achieving one of the aims, which is to up the ante in terms of the fines, because we've got a 7.6 million fine, does it really give us that consistency when Tesco are getting one fine for 7.56 and one fine for 160,000? I'm not quite sure that it does, given their greater certainty was one of the aims of the guidelines, but it is certainly up in the ante and sending a message to the bigger organisations. Another household name was British Airways, who's also found itself with a hefty fine this year. This was in June, and that case involved a vehicle collision. In March 18, an employee had been struck by a tug pulling a train of dollies, which are those vehicles that you'll see pulling transport baggage around. And she was knocked under another tug, and it wasn't a fatal incident, but she sustained some serious crushing injuries. And the HSC in that case found that the injured worker was using the centre of the roadway between the two lanes as a walking route, and that had actually been common practice for 10 years, so a real long-standing breach. And the investigation identified some significant failings in the management of health and safety and workplace transport risks, including issues relating to supervision and monitoring, risk assessment and training, all real basics which you'd think an organisation like BA would have sorted, but clearly not, and particularly surprising that the breach had been ongoing for so long without it being dealt with previously. So again, we've got a Section 2 prosecution there and a guilty plea, and BA were fined 1.8 million in order to pay costs of £35,000. So you see there that the court is still, whilst those figures were coming down in the charts that we looked at earlier, the court is still imposing some hefty fines. A couple of examples here of cases which are still hefty fines, but not as commonplace as BA and Tesco. We've got Briar Chemicals Limited, and in that case, that's quite a recent case from the last couple of months. A maintenance contractor was carrying out some repair work on a mixing vessel during some planned shutdown maintenance, and in that case it's thought that his welding torch or his grinder accidentally ignited a flammable vapour inside the vessel, which shouldn't have been present when the work was commenced. And really sadly, in that case, he was working alongside his son when the accident happened, which must have been very difficult. It was a HSE inspection, and they found that they failed to take all reasonable measures to prevent the explosion, and they pleaded guilty in that case to Regulation 5 of the Code of Regulations, and they were fined 1 million in order to pay costs of 11,000. Unfortunately, I've not got indication of what turnover is in these couple of examples. The HSE don't provide that information because that's always helpful to see. But with a fine of 1 million, I imagine that it was still quite a high level of turnover to reach that particular level of fine. And a similar fine here for enterprise managed services. This was Northampton Crown Court heard that in April 16, an employee was fatally crushed when he tripped and fell under the wheels of a lorry whilst on a routine collection of recyclable refuse. An investigation into HSE in that case found that a suitable and sufficient risk assessment hadn't been carried out for the collection route, and there was a failure to adequately supervise the waste and recycling round. That was a guilty plea to Section 3, which is the same offence as the Section 2 that we've talked about, save that applies to non-employees rather than employees. And again, in this case, that organisation was fined 1 million in order to pay costs of 60,000. I feel that it would have been remiss of me not to mention the Bosley Mill case in this sentencing update. I'm sure many of you are familiar with the Bosley Mill explosion from 2015. And again, this is a case that's been in the press a lot over the last 6 months or so. And that accident, sadly, in 2015, 4 people were killed following an explosion at a wood mill. There's a 12-week trial which ended in April of this year. And that case, the trial had started with gross negligence manslaughter and corporate manslaughter charges and health and safety at work charges against managers. They were dropped at half-time following submissions made by the Defence Counsel in that case. And ultimately, the company ended up pleading guilty to Health and Safety at Work Act offences rather than corporate manslaughter, and it was fined £75,000. And the MD in that case pleaded guilty as well to Health and Safety Work Act offences rather than the manslaughter offences. And he was given a 9-month suspended sentence and a fine of £12,000. If anybody is interested, this case involved, as well as the sentencing aspect of it, the case involved some really interesting arguments on causation in manslaughter and in health and safety cases. And it really highlighted the difficulty in proving causation. Because what the court said in that case, that where there are a number of possibilities as to the cause of an accident, then not only must the prosecution adduce evidence in support, but they must also satisfy themselves that those other causes didn't contribute and didn't cause the accident. Because otherwise, if there are possible causes which could have caused the accident and the defendant isn't guilty of those, then there isn't sufficient evidence for a court or a jury to be sure, as they need to be, to convict. So it's really interesting, and I'd certainly recommend some further reading on that. And there's actually the Health and Safety Lawyers Association website have got a brilliant webinar from the 4 barristers who were involved in the case, and anybody can access it. And I think it's about an hour, but you can watch it at your leisure. But it's fascinating in terms of the causation arguments and gives a really, really in-depth overview of that case. So I'd certainly recommend it for anybody who might be interested. Okay. Hot topics. As I said, I did say that I'd refer to COVID again, unfortunately, because obviously for some of us, people have been back at work for a long time now, and for some others, COVID and coming back to work is new. Certainly, I think in office-based environments, whether that's purely office-based or organisations where people who work in in factories or the hands-on, they may have been back in work for some time, but employees who work in offices are still coming back into the business. And it's important to remember, particularly as these restrictions are now lifted and everything is allegedly returning back to normal, that whilst that is happening, the duties still remain the same on you as organisations to risk assess against COVID. I think it's very easy to fall into the trap of forgetting about it now as things move on, and we're not required to use face masks and social distance in the same way that we were previously. But the current guidance from the government is quite clear that we should still be following those 6 steps to make sure that we're applying COVID, as they call it, COVID secure principles, and trying to protect our employees. So the risk assessment is still key. The risk assessments that you're doing must still be taking into account COVID and what measures you need to have in place. Ventilation is the second point, and there seems to be a real push from the HSE at the moment on their LinkedIn, on their website and Twitter and so on. They're really pushing the importance of ventilation and making sure that you've got sufficient ventilation in the workplace. Cleaning touch points is the other one. We've all heard again from day one the importance of cleaning touch points and hand sanitizer. That's still at number 3 on the government's list. For workers not coming into work when they're showing symptoms, that's obviously still really important. And I do wonder whether that's going to become more difficult for organisations as we approach the winter months and all those winter bugs come back around. So it's important to give some thought as to whether general illnesses you want to make employees much more aware of their own personal obligations to consider whether they should be coming to work, or whether anybody exhibiting any kind of symptoms is told not to. I think that needs some thought, because it is going to become more difficult for employers as we get into the winter. Providing options for people to check in. Now, most people, including me, have probably deleted that dreadful NHS app. But there's still a suggestion that you should be considering, not that you must, but considering providing people with an opportunity to check in, so that they can then obviously assess if they've been in contact with somebody who has COVID, and it supports track and trace. So it's not an obligation, but they're suggesting that you should give some thought to it. And communication, lastly, communication, the importance of communicating to employees, customers, and anybody else who's coming onto your premises what your measures are and why you're doing them, and making sure that as things are updated, that you're updating staff and you're updating people coming onto your premises. Again, particularly, it's so fast-paced, isn't it, in terms of the guidance from the government and how quickly it changes. It's important to keep yourself as up to date on that as you can, and making sure your procedures are amended quickly to reflect the government guidance. Work-related stress. That's something which has been on the HSE's radar for a few years now, in terms of the importance of that and ensuring that you are assessing employees for work-related stress and well-being. But it's certainly become more and more prominent as a result of the pandemic. We've all heard all the stories of employees finding it difficult, understandably, at home, people lone working, people being isolated. And it's important that as employers, you are making sure that you're keeping track of employee well-being and ensuring that you are conducting work-related stress risk assessments. And that's difficult if you've got employees at home. Obviously, without having that face-to-face, it becomes much more difficult. But it can't be out of sight, out of mind. It must be keeping up to date with risk assessments, keeping in touch with employees and making sure you've got all that in place. The HSE I suggest on their website, we lose 11 million working days because of stress at work, which is huge. And they really highlight the importance of talking to employees and conducting your risk assessment. And there's some really helpful guidance on the HSE's website about this, with talking toolkits and things to help encourage that dialogue between you and your employees, you know, all your employees, but obviously particularly those who aren't necessarily in front of you on a day-to-day basis because of the new working arrangements, which have become the norm. And then we've got the Ppe Consultation. Some of you might be aware of this. So there's been a recent consultation around PPE, which closed just very recently. Now, PPE, as you know, in this jurisdiction, we've got the Personal Protective Equipment Regs 1992, and they're the regs which define PPE, and they're the regulations which set out obligations in terms of what's required. But at the end of last year, and I think this went relatively under the radar, there was a court judgment which found that the UK had failed to transpose some of the EU directives into domestic law relating to PPE. And that is essentially around who the obligations are towards in respect of PPE. So obviously we all know that employees are employees with an employment contract. We have obligations in terms of the provision of PPE. But what the European directive suggests is that it doesn't just apply to PPE, it applies to what they call workers as well. And as it stands, the UK legislation only applies to employers, it doesn't apply to workers. So the HSE are proposing to amend the legislation so that it includes workers as well. Now, as I say, an employee is quite straightforward. It's someone with a contract of employment. The definition of worker is unnecessarily long-winded, in my view, and we've distilled it down slightly to include workers are people who carry out casual or irregular work for one or a number of organisations. They might be workers who receive holiday pay but don't have other employment rights, such as statutory notice after 1 month's period of continuous service. It's people who only carry out work if they choose to. People who have a contract or other arrangements to do work or services personally for a reward, and they only have a limited right to send someone else to do the work. And then people who are not in business themselves, so they don't advertise services to customers, but people can then also book directly. So it's worth having a look to see if your organisation has workers which fit under that definition, because it may be that many organisations are already applying the provisions to workers and hadn't actually appreciated that it was only limited to employees. But if not, and you do have workers and you aren't providing PPE, bear in mind that this legislation is coming. The consultation has just closed. So it'll be interesting to see what feedback the HSE give. I think there was some suspicion from the HSE that there might not be as many limb workers as they originally thought. So it may not impact on as many organisations as they thought, but it'll be interesting to see the outcome of the consultation and the changes that are then made. But I can't see this not coming into effect. So if you have got those workers and you're not providing PPE and complying with those obligations, it's something to give some thought to now before we move towards the introduction of some further legislation. Okay, and I'm conscious that I'm overrunning my time, so I'll speed up, Michelle. What's on the horizon?
It's okay. I'm still. We've got a couple of questions at the end anyway.
Okay, lovely. All right, great. What's on the horizon? So, COVID. I'm back to it again, but COVID, as I said earlier, resulted in a lot fewer HSE inspections, a lot fewer HSE prosecutions. And we're seeing now that as things are getting back to normal, the HSE and local authorities are out there back to their day-to-day business, and things are really starting to pick up now. And I think there's some concern that because there has been, quite understandably, so much focus on COVID and people making sure their businesses are COVID compliant, that there's a risk that as the HSE now come out and conduct non-COVID inspections and they get back to the routine business, there's a risk that those other measures have fallen by the wayside because there's been so much focus on COVID that our usual risk assessments and procedures have perhaps annual reviews have been put back because resources have been directed at COVID. So now is the time to make sure that everybody is up to speed and making sure that we haven't missed anything and nothing slipped in terms of the general health and safety measures that you have in place, because HSE, as I say, they're back out there and they're getting back to usual business. So it's being prepared for that inspection. So if they do turn up, your COVID risk assessments are done, but also everything else is in place and up to speed as well. Smart PPE is something which is also an interesting topic, which I think is going to become more and more prominent over the next, certainly over the next couple of years. So smart PPE or wearable technology is another way in which it's referred. It's early days, but the developments in technology are already showing a move towards more smart PE and wearable technology. A lot of you might already be familiar with equipment such as the ReactTech device, which relates to hand-arm vibration. So just in case there are people on the call that aren't, rather than relying upon individuals to record exposure for HAVs, the ReactTech device is a watch that they wear, and it's connected up to a software system, and you can set limits of exposure on the device, and the device, as it then reaches those limits, will start to make noise, flash, vibrate, which I always thought was quite interesting given it's trying to control vibration that this device vibrates, but that will then alert the user, and it will alert management, and it will then feed back into the central system. And it's really helpful, and it takes away that possibility of there being human error in the recording of exposure because the device does it for you. And a lot of organisations have used that or something similar for social distancing in the last few well, I suppose 18 months or so now with the pandemic. So using that as a way of detecting how close somebody is. So that's been useful for social distancing. And we're now starting to see other devices come onto the market, such as I believe Travis Perkins and Wincanton are using a device which employees wear between their upper back and shoulders, which alerts them if they're not manual handling correctly. Manual handling, I'm sure from a claims perspective, you'll see a lot of those. And the device will send a message then to a tablet or a computer that it's connected to, identifying the problem, raising it, and then generating some training courses that the individual might want to look at. So that's really helpful. And I think as technology improves, we're just going to see more and more of those devices that are aimed at taking away the human element of it, and improving safety, ultimately, is what they're aimed to do. And in the long run, saving time and costs for employers. And I think from the HSE perspective, they're going to be very interested to see if you have a case and you have this technology, they're going to be very interested in the quality of that technology and making sure when it comes to the defensibility of that claim, has there been research? What's the research like to back up this particular piece of technology? Who was the supplier? Are they a reputable supplier? Have you trained your employees properly? Do they know how to use it? And is there some monitoring and supervision? Because there's no point in having a device like this if you're just going to sit back, let the device work as intended, but nobody's going to monitor and supervise the results that are being generated from it. It's not just reliant upon the device, you still need to monitor and audit that. So it'd be interesting to see over the next few years how that the usage of the technology increases, and the HSE and other prosecutors' reaction to it when it comes to defensibility of claims. And then finally, fire safety and the Building Safety Act and the new regulator. Again, this is something which, following Grenfell, right, we've moved on. There we go. Following Grenfell, this is something which has obviously been at the forefront of everybody's mind, and there was the Hackett review into fire safety. So again, this is quite a chunky topic and can be an update in itself because there is a lot going on, but short summary, in April of this year, the Fire Safety Act 2021 received royal assent, and that amends the Regulatory Reform Fire Safety Order 2005, which again, I'm sure many of you will be familiar with. And what that does is provide some clarification on the scope of the RRO. It sets out the duties of a responsible person with regards to management of fire safety in non-domestic premises. And it clarifies that the RRO applies to all multi-occupied residential buildings, not depending on the height. And it means that responsible persons must now assess, manage and reduce fire risk posed by the structure and external walls of the building for which they're responsible, cladding, balconies, windows, and all individual doors, including doors to flats that open into common parts. So this piece of legislation is important, and it's expected to come into force towards the end of this year or early next year. And closely linked to that, we've got the Building Safety Bill, which was published in the summer. And this deals with high-rise safety buildings and how they should be constructed and maintained. And again, is obviously very relevant to the Hackett Review and Grenfell. And what that new regime also does is create a new building safety regulator to monitor compliance and take action when needed. That piece of legislation isn't in force just as of yet, and we expect that'll be towards the end of next year before we see a gradual implementation of the rules. But in the same manner that we discussed the PPE change to the regulations, the advice really is to comply now. So if these particular elements of the legislation is relevant to you, don't be reactive, be proactive, and start to consider what your obligations will be under the new regulation, and put measures in place now so that you're not taken by surprise as and when we get to the end of this year for some of it and the end of next year for the rest. Okay, slightly beyond schedule. Hopefully you all found that really interesting, and apologies that you've listened to me talk. I know it's a bit more difficult for these things to be interactive virtually, but I'll happily take any questions that have been sent through. Thank you.
Thanks so much, Lauren. So it's really interesting, I think, for people who are from, some of those industries as well, just to listen to, the culpability of like the management teams and stuff like that. There was some dialogue in the chat over, the Tesco fines and about the bearing of guilt as well, and how that factored into the fines, whether that's right or wrong. We had a little bit of dialogue there in the chat. Then there was another question from Sam. Sam, if you're there and you want to unmute, feel free. Just a question on the PPE, the new PPE regs, and the widening of the term of a worker. So the thought is now, does this mean like people like consultants who are carrying out singular duties or singular sort of assignments, if you like? So the question was, would it have a bearing on IR35? Consultants and things, whereas it wouldn't have done before because they're not direct employees, I think. Correct me, Sam, if I'm wrong.
Hiya, yes, I'm here. Because I wasn't very familiar with the Ppe Consultation, and I was just interested in the definition of a worker and how far that be applied to people like consultants who do basically the same work as an employee. And obviously at the moment there's I think the IR35 argument in terms of establishing how much like an employee they are. And I just wondered whether that had been used as well to determine whether or not PPE should be given to these individuals.
Thanks, Sam. I didn't see any reference to that, if I'm being honest, in the HSE documentation in relation to the consultation. What I'll do is I'll pop a link in the chat in a moment to the HSE documentation on it. As I say, the definition of worker is probably likely in the future got the potentially to cause some difficulty in this respect in terms of who it actually applies to, because I don't think it's particularly easy to understand. As I said, workers carry out casual or irregular work for one or a number of organisations, which might well include, might it, some of the consultants that you might use. So where there's PPE that's relevant that needs to be used, then it might well start to extend your obligations to those types of individuals. So I think it'll be key if any of you do have those sort of contacts where obviously in some scenarios the PPE won't be relevant, so it might be that it does technically apply to certain contractors and so on, but it's not relevant. But where it is, and you'd be expected that to wear PPE, then yeah, you may find that the obligations extend to those people, which it might not have done previously. So I'll pop the link in there, and everybody keep your eyes peeled for the outcome of the consultation and where we get to in terms of the HSE guidance.
Thank you.
Okay, thanks, Sam. Thanks, Lauren. There's another question here sent in from Nigel Barlow. Again, I'll give you a couple of minutes if you want to. Feel free to unmute and ask yourself. Or I can ask it. So I've got a question in the chat. So what happens in civil cases where there's a mismatch between health and safety legislation description of an employee and the policy definition?
Good question. Is the question, let me just read the question again,
yeah,
Michelle.
It's in the chat. If you just go in the chat. No, I don't think it's in the chat. I think it was sent to someone and then redirected to me because I run the chat. Yeah,
Just
what happens in civil cases where there's a mismatch between health and safety legislation description of an employee and the policy definition? Yeah.
No, that'd be interesting. What I'd have to do for that one is take some advice from a civil colleague. It's not my area of expertise in terms of once we've dealt with the HSE prosecution, our civil team will deal with it. I think that's probably in respect of if there's this change to the PPE that then becomes relevant, or is that a general?
Yeah, I think it's just from a civil aspect. I think from what I got from your presentation, you're talking about companies and their duties with employees. But if someone's taken a civil case, it would be slightly different, wouldn't it? If someone's taken a civil case, you would have to. The factors would be wider, wouldn't it? So I think what it's done is it's opened it up, hasn't it, from making it just about employees, making it now for, capturing all of those other people who may just be coming in transiently and going off sites and things like that. So it would be interesting to see what comes out of it. Yeah,
a much wider group of people. Michelle, I can touch base with a civil colleague as well and just get a bit more advice on that, and I'll send through a response to you which you can disseminate to the members.
Yeah, okay, so I've got, I'll just make a note. So Nigel Barlow, you've asked the question. So if you just give us a message, just message me on LinkedIn, then I can share a response from Lauren if you like. So I don't think there's many more questions. If anybody's got anything that you want to ask to Lauren, feel free to unmute yourself if anyone. There's lots of thank yous for an excellent presentation as well, Lauren. So you got loads of
thank you, everyone.
Nice feedback in the chat as well. Like I say, it's going to be recorded this anyway. And then put on. So if anybody joined us, because I know some people have had meetings overlap or running a bit late and things, so it is going to be recorded. It takes a day or two to go onto the micro site, and then you can download any previous one. So has anyone got any questions?
Yeah, can I chip in, please?
Yeah, Peter. Yeah.
Right, Lauren. It gets a bit messy, this PPE thing. I did a lot of work at Sellafield, which is, as you know, can be a bit radiation hot. And the PP was provided by Sellafield, and we handed the PPE back when we finished work. I was a consultant, working via another company, if you like. So, if I wasn't an employee of BNFL, I was an employee of somebody else, but all our PPE was looked after by BNFL. And I can't see an external organisation being able to look after radiation contaminated clothing, for instance.
No.
So that's where it gets very, very foggy. Yeah,
it does. And obviously that if the employer with the company who you are technically employed by will retain their duties in relation to this, irrespective of what other how it might appear, I suppose, it depending on how the contracts are arranged, even though it might, if you are still technically employed by another organisation, they will still retain the duty to provide the PPE, even when you may be, working off-site or in another particular organisation where you remain an employee. They still obviously can keep the duty. The worker's definition, which I've sent the link through, which everybody might find helpful. Somebody who carries out casual or irregular work for one or a number of organisations is probably one that might cover the majority. So where you're not employed by a particular organisation, self-employed, but you carry out casual or irregular work for then a number of organisations without having a contract of employment, in that situation, that's when the employer, or the organisation, is then in a position to ensure that you're provided with the necessary PPE. But I agree, it contractually and in terms of the organisation that this is going to require, it might become quite difficult. And it'll be, as I say, I'm sure there's been a lot from the industries in terms of the response to that consultation to make sure that it does give clarity. Because at the moment, as it stands, and obviously employers ensure their employees are protected, and if you're self-employed, you will provide your own. But this situation does create a bit of a grey area. It will be interesting to see whether there's any changes to the suggestions at the moment as currently drafted by the HSE.
Yeah, thank you.
Yeah, I agree, Lauren. I mean, I think for most people on this call, there'll be a number of people who are acting in, a consultant capacity, and you turn up, obviously, as most people would, acting as a consultant, you turn up for whatever assignment you were on with the specific PPE. However, they may want you to go and look at another area of their factory, or like Peter said, if it's a higher risk and you've not been there before, there might be additional PPE required. And I think it'd be good to see some guidance where it's made a mandatory thing, where that the upskill in PPE, say, is passed over to that person to make sure they're safe, rather than leaving it as, oh well, you've not brought your PPE so you can't go. I think it'll be really good if it's taken out of the grey area box. But yeah, really interesting to get an update. I say it's not been updated since 1992, so I think
it's been a long time.
Well overdue.
Yeah, and even this was a mistake. Nobody realised until November last year that it didn't quite cut it in terms of the regulations. So really interesting development.
Has anybody got anything else now? Because we're just approaching 3. Conscious of your time, Lauren. And
no, don't worry. No, not at all.
Has anybody got anything else that they want to, before we go on to the short networking session with the branch? Anything else?
I just had one question. It's a Zoe Grocott. It's going back to the first part of your presentation with regard to COVID-19. You mentioned that there was 74 deaths awaiting decision to full commencement of full investigation. Do any of them relate to COVID?
Yeah, so so those particular stats, I've got my slides in front of me, Zoe, so I'll just pop back to those. Let me just come back to it. Oh, sorry, I'm having a bit of a technology issue here. So investigation of 74 deaths and inquiries to decide whether to commence a full investigation are ongoing in a further 89 cases. So there's currently an investigation as to 74 COVID-related deaths, and there are another 89 cases. This was in April, so the figures will have changed slightly. There's a further 89 cases where the investigation inquiries are ongoing as to whether they're going to commence a full investigation or not. So that's at a slightly earlier stage. So no doubt that's come from Rideau reporting or concerns being raised by employees or other organisations. So they're in the pipeline at the moment. I think a lot of it, in terms of the way the HSE are approaching it, will be they're just being cautious. They're doing this on a cautionary basis, just to make sure that there isn't any glaringly obvious breaches of the COVID regulations. I know we act for NHS trusts as well, where there's had to be some necessary reporting, and and even in all those cases, even though actually it might look like there might be some workplace exposure, HSE have taken a sensible view in respect of those investigations as well, because again, as we said earlier, they appreciate that we are all dealing with something which is totally unknown here and a very difficult subject. So whilst there are those investigations in relation to those COVID deaths, I don't expect them to result in any prosecutions.
Yeah, that's really interesting. Thank you.
Thanks, Zoe.
Thank you.
So if anyone's got, if nobody's got anything else, we'll let you get back on with your day, Lauren. Anyone who wants to, feel free to ask any other questions of the committee, feel free to do so. But thanks so much for your time. It's really appreciated, and we'll share these slides if you don't mind. With,
yeah, of course. Yeah.
So.
No, thank you everybody. Thanks for joining. It's much appreciated, and thanks for all your questions. It's always really great when we can have some interaction afterwards. And happy to circulate the slides, and my email address is on there as well. So if anyone's got any queries, feel free to get in touch. Enjoy the rest of your afternoon.
Okay.
Thanks everyone. Bye.
Bye. Bye. Hey, Paul.
Hi, Michelle. Hi, everybody. We are going to stay on for a few minutes or so, as we do. So, Brent, if anybody does feel has any questions, comments, observations for either the committee or anybody else on the call, feel free to unmute yourselves. If not, obviously, thanks so much for joining us, and hope to see you again shortly. Let's see if people are dropping off. Going back. I think.
Yeah, there's some really good feedback.
Michelle.
Pardon?
Is that your dog snoring in the background?
Oh man. Yeah, and he's moved away.